Good afternoon. We're back again. Those Rogers Reedy people. No, we're back again. Thank you for attending today's session for Rogers Reedy's Lunch and Learn Accountants series. This is a second in this series, which is specialised for accountants in and around Australia. And we have a great presentation, which I'll talk about shortly. So welcome to our Lunch and Learn session number 2. My name is Brent Morgan. You've probably heard me speak previously on some of our webinars. I'm a director of Rogers Reedy Melbourne, and I've been a director since its incorporation many years ago. Today, we've got 240 people, accountants and staff around Australia listening to our webinar. A great number, and it just shows that it is a topic that that accountants come across often, and we've got the right person to talk about it clearly. So, but we'll talk about Daniel very shortly. Now, for the people who are new today to our webinars and new to Rogers Reedy, who is Rogers Reedy? I like to remind people who we are. We are a leading national insolvency and forensic firm. We have offices in all states and territories around Australia, and we also have offices around internationally as well, and part of our BTG Global Advisory Group. We do small work, we do big work. We're across the spectrum in the size of the type of work that we do in insolvency and forensics. So, what are we seeing at the moment? Before we get to presentation today, I thought I'd just give a rundown on what we're seeing in the insolvency space. We're really seeing the turnaround and restructuring space open up. The small business restructuring regime that started on the 1st of January is whilst it hasn't been used as much as what the government would like it to be used, it is a great opportunity we're seeing for small businesses to restructure their debts. We've commenced one in our Melbourne office for a business that has debts of under $1 million. Principally, they have a ATO debt of about 700,000. They are going to, and they are operating through the regime. We've been appointed as the small business restructuring officers, and we'll be putting a proposal to its main creditor, which in this case is the ATO. And it's there really for businesses to turn around, and we see it as a great opportunity for those businesses that have predominantly ATO debt to do deals with the ATO and continue to trade during that space. So call us if you want to discuss it further. I know that a lot of people don't know a lot about it, but it is a new regime that's coming forward. Today we have 2 great presenters. So we have Daniel Myers from Schitzer Papaleo. Get that.
It's a Papaleo.
I knew I'd get it wrong, Daniel. I shouldn't have put those marbles in my mouth, but Daniel's here to speak with one of our great presenters and directors at our firm, who's Mark Ellis. Mark, along with Gary Fettis, are our insolvency and forensic team, and they head up the Rogers Reedy forensic team. So, and they're both talking today on binding financial agreements. So, thank you for attending, Mark. I'll let you do the introductions to Daniel, and hopefully you pronounce his firm's name better than what I do.
Well, thank you very much, Brent. So in case you weren't listening, I'm Mark Ellis. I'm Associate Director at Rogers Reedy Forensic based in Melbourne. For those of you maybe know our insolvency services, but you don't know our forensic services, we offer 3 key services, really. Those are business valuations, litigation support, and investigative services. Today's session is obviously focused around family law issue, and most of the work that we do in the family law space involves business valuations I conduct the majority of the family law business valuations for Rogers Reedy, and I just thought before we get into Daniel's presentation, I'd share a couple of pieces of advice that I've learned from doing this work over the years. The first one of those is usually in this space, at least one of the parties to the proceeding has no idea what the business is worth, and that's usually sort of expressed in the form of they think it's worth an awful lot more than it actually is. The second thing that I've learned is that whilst obviously an accurate valuation is important, probably what's more important and where we really try and add value to the process is making sure that the ultimate client, who is usually an unsophisticated in accounting terms, is able to understand what we do. So it's very important that when we produce documents that they are in a transparent and clear manner with everything set out. We sort of believe that if your report can take someone on a journey and you maybe help uncover the business valuation as you go through in a step-by-step procedure, and they can sort of break it down into small steps and understand each of those small steps and builds on itself, then you'll find that they'll get a bit more, you'll get a bit more buy-in, and you'll get less resistance to what your ultimate conclusion is. And it's I sort of think of it as analogous with if you've got young kids and you want to get them to eat their greens, then you have them help cook the greens and cut them up, and then they want to eat them at the end of the day. So you take them through and help them understand it, and then they can take their medicine, which is they maybe don't like the final answer of the valuation, which is just how it happens to come sometimes. Now, obviously, family law and binding financial agreements, they are something that you won't see every day in your work if you're listening today. But of course, if you are listening today, that means you're in a very privileged position with your clients. You are that trusted business advisor, and being able to give some advice on a binding financial agreement or a family law thing, perhaps before your client even realizes that they need it or doesn't even consider that they need it, that's a great way to cement that relationship, and that's a great way for you to add value to your clients. But if you are going to be doing that, then obviously you need to be comfortable to look at what the signs are and the things maybe that might trigger the conversation. And also, it's very important that you've got some experts to rely on, like Daniel. But anyway, look, that's really enough about me. I'll just give Daniel a quick introduction so you all know what good high-quality speaker we have today. Daniel is a man of many talents, as well as being an expert on binding financial agreements. He is a special counsel at Shetzer Papaleo, and I hope I said that better than Brent. He is a qualified mediator, and I believe he's studying a master's in psychology at the minute, because it's all about that holistic approach to family law. But perhaps most impressive of all, Daniel probably doesn't know what I'm going to say here, but he will remember very shortly. Daniel spent a season as Sir Alex Ferguson's official tea-boy at Manchester United in his youth, and not many people get to have that on that CV. So over to you, Daniel.
Oh, thanks, Mark. Yeah, that's 20 odd years later, 25 years later, that's still on my CV. But yeah, no, thank you for that kind introduction. What I'm going to do is I'm just going to share my screen onto the slides here. All right, should be ready to go. So hopefully you've got the slides up there. Is that right, Mark?
Yes, that's great.
Yeah.
I can see them.
Okay. All right. So well, you've just done my introduction for me. Thank you for that. So I'll get on with it. Celebrity prenups. This is really what many people conjure up in their minds when they think about in terms of what a prenup is. So in the past, it's been thought of as a romance killer, maybe reflecting a lack of commitment by one or both parties to a marriage, or subject to the celebrity stereotype of a rich old man marrying a gold digger. So these are the examples. I'm not going to go through them in detail, and hands up, I'm not even sure if any of them are true. The funny thing is, though, when I was actually reviewing this the other day, I was reliably informed that Kim Kardashian and Kanye West have now split. So thankfully, the information on this slide appears to be correct. It mentions that the prenup doesn't have a child custody clause, and that all the money that Kim earns from her TV show and fashion lines are solely her property. I did do a quick Google search earlier, which tells me that according to Kardashian's court filing, they kept their property separate throughout the marriage because of the terms of a prenuptial agreement. So there we go. And then, of course, hot off the press just this morning, I'm sure you've all seen the news that Bill and Melinda Gates have announced their divorce after 27 years. I've no idea if they've got a prenup, but Bill is apparently still the fourth wealthiest person in the world with $124 billion. So it'll be interesting to see how that plays out. My point here anyway is that for a long time, this has been the perception around prenups there, that they're just part of the celebrity culture, and it's about as likely would need one as it is that we may end up marrying someone like Brad Pitt or Beyonce in the first place. Back in the real world, these types of agreements aren't anywhere near as colourful, but they are a real thing that normal people do in Australia, as Mark alluded to earlier. Before 2000, parties to a marriage couldn't contract out of the Family Law Act, which is the law that actually outlines a person's entitlement to a property settlement or, in some cases, financial support known as spousal maintenance. However, back in 2000, the government changed the law to allow a couple to enter into a financial agreement, what's loosely referred to still as a prenup. In a nutshell, the effect of these agreements is to exclude the power of the court to make financial orders between a couple. So in the 20 years since, the Hollywood perception that I mentioned a few minutes ago has gradually changed as people realize that financial agreements can be a practical form of insurance against financial loss that often accompanies the end of a relationship, whether that's a marriage or, since 2009, a de facto relationship. And that makes sense when you consider the number of divorces that there are each year, even aside from de facto separations. In 2019, there were 114,000 marriages registered in Australia and about 50,000 divorces granted. So that's a divorce rate roughly of about 43%, albeit obviously not from the same bunch of people in that year. Couples can enter into a financial agreement at any time. So, for example, those who are engaged or planning on getting married, those who are currently married, or who are planning on moving in together or starting a de facto relationship. It also can include those who have already separated or even divorced, but that's a slightly different concept, and my focus of the presentation today is to essentially to deal with couples who are in an intact relationship and want to set out what arrangements there will be for division of assets in the event that they do separate. Are financial agreements unromantic? It's an interesting question, asking that as a family lawyer. Romance and divorce lawyer aren't usually used in the same sentence, but anyway, my view is that it's probably not the sort of thing to bring up on a first date, okay, but there's probably lots of things that most people wouldn't or shouldn't bring up on a first date either. Whatever the awkwardness involved, a financial agreement is intended to act as an insurance policy and possibly a very valuable one. There is still some stigma around financial agreements, but the feedback I often hear is that, at least in the right circumstances, entering into a financial agreement can actually strengthen a relationship. The lines of communication are opened, and the issues that are raised that the couple may otherwise have to face in the marriage. For example, whether one party should look after the children rather than being paid employment, and their respective financial priorities. Areas of potential conflict are often highlighted and either resolved at an early stage, or in some cases the couple recognize that they're ill-suited. A well-considered financial agreement isn't about being unfair, but it is about reducing the potential for a dispute, which is usually the worst and most costly part of a separation. So in terms of the advantages of a financial agreement, there can be many such benefits if it's well considered and drafted appropriately by good lawyers. In fact, this may come as a surprise, but my presentation is actually not going to be a one-sided sales pitch for financial agreements, far from it. While they do have their place, these agreements do come with a high degree of caution, they need to be handled with care and are by no means suitable for every case. I will come on to that a bit later, but with that proviso, the benefits are as follows. Certainty. So a financial agreement gives greater control and certainty to parties over their financial affairs than a family law act can provide for, particularly given the large discretion given to judges to decide cases. In terms of finality, a financial agreement sets out how assets will be divided in a way that, at least in theory, ensures that the family court can't override or alter the agreement. So the aim is to ensure that any potential dispute is dealt with by the agreement itself. Security. A financial agreement can offer peace of mind about how future arrangements will be carried out, meaning that both spouses can make better plans without worrying about what will happen into the future. Tax benefits. Transactions that are carried out pursuant to a financial agreement attract the same benefits as court orders, so that parties who are to exchange or receive property get the same rollover relief on capital gains tax and are exempt from stamp duty on transfers of property. They're private agreements, so only the parties and lawyers involved in working on the agreement get to know anything about them. That's different from court proceedings, which, although family law proceedings are technically confidential, just the nature of those proceedings often involves family and friends being called as witnesses, and proceedings are viewed by other litigants in court and so on. In terms of time and cost, it should enable a much speedier resolution of financial matters at the end of a relationship. Once parties agree on the terms of a financial agreement, the agreement itself and the accompanying advice can be prepared within a relatively short time frame. If parties separate without a financial agreement and they're unable to agree on a settlement, it will usually cost much more than preparing the financial agreement, and especially if they have to go to court, it can take months and sometimes years to resolve. And then finally, there's the less tangible personal factors I mentioned earlier. So, for example, the process itself forces parties to sort out priorities such as having children as against employment or alongside employment, and promotes better communication in the long term, and it can remove a source of stress and so on. In terms of disadvantages, there is a counter argument to what I've just said, which is that there is a perception that financial agreements can suggest a lack of trust in the other partner, lack of confidence in the marriage, and is generally a bad or a negative start to a relationship. These are very personal and subjective matters. They're obviously extremely legitimate viewpoints as well. Agreements can also treat one party unfairly. For example, one party may be in a weaker bargaining position because they're more committed to the marriage than concerned over financial issues. Sometimes one party is prepared to sign a prenup which is not in their interest rather than risk the marriage not proceeding. That party is at a significant disadvantage in the negotiating process, as they can't negotiate objectively. We'll talk a bit more about how that may play out in practice a bit later on. So what does a financial agreement actually look like or include in practice? So here are some examples. It can quarantine, i.e. protect property that people accumulated before the relationship. Similarly, it can quarantine or protect property that that a spouse will receive during the relationship, such as inheritances or gifts from family members. There are particular benefits for those considering entering into their second long-term de facto relationship or marriage. Under the Family Law Act, all assets are available for division in the property pool, including inheritance and assets brought into a relationship. A financial agreement should outline practical matters such as who will retain the former family home or what happens to the investment property. It can outline the spousal maintenance that one party will pay to the other. although in fact it's much more common that the financial agreement will do the opposite. In other words, exclude the right of either person to claim maintenance from the other in the first place. I think some people are still surprised in my experience that what is called in America, I think alimony, does exist in Australia. It's called spousal maintenance, and it is a very common benefit of a financial agreement to exclude a person's right to claim that from the other, or protect against having to pay it, depending on your perspective. They're also used to protect a business. So, for example, if you imagine a small business partnership, if one of the business owners' relationship breaks down, that can have a significant effect on the business. The business would often be the most valuable asset, and a payout has to be funded to the non-business spouse, sometimes by the owner borrowing against their interest in the business. Even the fact of having an owner distracted by the legal proceedings that can last years, or having valuations or forensic analysis done to the business, can affect everybody else. So a financial agreement can set out what is to happen so that the non-business owning spouse is looked after, but is done in a way that protects the business and its cash flow, and is structured in a tax effective way. I've referred to financial agreements as that so far. I haven't actually referred to them as binding financial agreements, because there is a step that I'm about to talk about that actually turns them into, hopefully, binding financial agreements. And the requirements for that are set out in detail in the Family Law Act. Actually doing so, or actually fulfilling these requirements, is not a straightforward or simple process. For good reason. As mentioned, the intention of a financial agreement is to exclude the family court's jurisdiction. In other words, the couple are surrendering the significant rights they would have under the law to a property settlement or spousal maintenance. So as a check and balance, the law imposes various requirements into the process to ensure that there's fairness and transparency. That includes, for example, the need for each party to consult their own lawyer for independent advice. Both lawyers have to give detailed written advice about those agreements to their client. Both lawyers need to sign a statement of independent legal advice. And to ensure that and there was a need to ensure that the financial agreement complies with various other technical requirements that the clients themselves won't care about, but can make the difference between it being upheld or set aside. So when might a financial agreement be set aside? There are several ways that financial agreements can become undone. For example, fraud. So if a financial agreement is obtained, for example, by fraud, for example, due to a failure to disclose assets, that's why, as part of the process, it's important there is full and frank disclosure of both parties' financial circumstances. That doesn't mean to say that there needs to be or should be a forensic examination of the other person's affairs, or even formal valuations. But if a lack of disclosure is significant enough in hindsight, it could be sufficient to have the agreement set aside. If there's duress or some form of undue pressure placed on a party, which I alluded to earlier, some of you may recall in 2017 there was a high-profile High Court case that made the news. It was called Thorne and Kennedy. In that case, the court did set aside an agreement which casts doubt generally on financial agreements which are a bad bargain for one of the parties. It's an interesting case, so I'll just delve briefly into the facts of that. The wife was 36 years old when the parties met online. She was living in Eastern Europe. She didn't have any significant assets. The husband was 67, a divorcee with 3 adult children. He was a property developer living on the Gold Coast with assets worth about 18 million. Shortly after they met online, the husband told the wife, quote, "You have to sign the paper, my money is for my children." 7 months after they met, the wife moved to Australia with the intention of getting married. And then about 11 days before the wedding, the husband told her that if she didn't sign the agreement, the wedding wouldn't go ahead. unfortunately, the agreement was drawn solely to protect the husband's interests and very one-sided in his favour. The wife's lawyer, in fact, advised against her signing it, saying, I think words to the effect of, it was the worst agreement she'd ever seen. But the wife relied on the husband for everything and believed that she had no choice but to sign the agreement for the sake of the relationship. She did sign the agreement and the couple married. However, the marriage ended after about 4 years. The wife filed court proceedings to set aside the agreement and apply for a property settlement instead. And she was successful in arguing that she did sign the agreement under duress and was granted in the end $1.5 million from the husband's estate. In fact, the husband had died by then. There were appeals all the way up to the High Court, who said that the financial agreement should be set aside because there was what's known as unconscionable conduct by the husband in having the wife sign the agreement, and that the wife was also subject to undue influence. So this is a pretty extreme case, but it is a reminder for lawyers of the need for caution. Essentially, the court said that what may be fine in terms of commercial principles of contract law, they don't have any place in terms of regulating the financial matters of the parties to an intimate relationship. As far as I, as the lawyer, am concerned, if the circumstances are clearly that imbalanced, that it's obvious that it would be that there is something suspect about the process, then I would prefer not to act for that client. But ultimately, we act on instructions, and I may not know the sort of pressures that a client may be subject to at home or on these types of issues. The court has also emphasised the importance of strict compliance with the requirements stipulated in the Act. So seemingly small errors in drafting can lead to an agreement being set aside, despite the intentions of the couple when entering into the agreement. In terms of having children, if there is, if since making the agreement there is a material change in circumstances relating to a child or the care of a child which causes hardship to a parent, if the agreement isn't set aside, that is a ground for doing so. So I'll just break that down. It was a bit jargony. If the most common scenario where this arises is that a couple enter into an agreement, they don't have children at that stage, and the agreement doesn't make any provision for the inevitable change of financial circumstances when children arise. They have children, and the agreement turns out to be incredibly unfair in light of that. That itself can be a ground for setting it aside. So one way to address that is, in theory, you could project a few different scenarios into the future, but that itself can lead to an overly complex or unwieldy agreement. So a cleaner way of doing it is to have what's known as a sunset clause. So the financial agreement would only run up until the birth of a child, or you could try to make the scope of the financial agreement less ambitious in the first place. I'll come on to that in practice in a moment. Relating to these concerns is that if the agreement is too uncertain or impractical to implement, it could be set aside. This is a trap if the agreement is too unwieldy from the start. And the challenge with financial agreements is that the aim is to achieve both certainty, so it's clear that how an agreement will be interpreted if it's ever called upon, but also flexibility to recognize that a family's finances and circumstances are constantly in flux and may be very different at the time of a separation than they were at the time of an agreement. And so sometimes those two competing demands, certainty and flexibility, can conflict. So overall, it's fair to say that that financial agreements are not straightforward or easy documents to prepare, and they're not cheap either. But if they're well drafted with good lawyers on both sides, that will certainly go a long way, and more likely than not, they'll be upheld. I have, in fact, however, come across some very poorly drafted agreements, probably done on the cheap, but it ends up being a false economy. So terms of some of the other practical issues and challenges, hopefully I haven't scared you off financial agreements already, but these are some of the more common day-to-day practical issues that I do come across in a typical agreement. Quite often clients have a clear and simple intention in their mind of what they'd like to achieve at the start, but what actually when you drill down into the detail, it's more complex and there's thought through. A common example is that where a client says they want to protect or they want to quarantine their initial assets. That sounds fine in theory, but then what? Those assets don't usually remain in a vacuum. They would get sold and the proceeds transferred into other forms, including into joint assets. Another consideration is how to divide future assets that parties accumulate together. For example, will this be based on future financial contributions, or will it be based on what the legal title to property says, or will they just be divided equally, or by some other criteria? Dividing equally would be the most straightforward, but not necessarily agreed to in every case. Dividing property based on financial contributions sounds good in theory, but a downside of this is that it may require a retrospective tracing exercise at separation. In other words, it requires the parties to keep bank statements to undertake a mathematical analysis to determine their entitlements. Unless they've kept good records, that might open the door for a court to set aside the agreement on the basis of uncertainty or a dispute about what the alleged contributions were. And then related to all these factors is the fairness consideration. In other words, what may be appropriate now may not be so in the distant future when the couple's personal family circumstances may be very different. For example, the scenario I mentioned earlier about the impact of having children during the relationship. So some of the solutions include the sunset clause that I mentioned in the event of having children. The agreement could, by stages or steps, reduce the amount of protection given to initial contributions and increase the entitlements of the party who made less initial contributions. The problem is staged entitlements makes the agreement more complex and therefore more costly to negotiate, draft, interpret, and implement. My preferred solution often is to enter into a limited financial agreement that deals only with current property. So, for example, the husband would get what he brings into the relationship, the wife gets what she brings into the relationship, and no other property is covered by the agreement, so that if they do separate, that other property will then be divided according to normal family law principles decided by a court based on what is fair at that time. So now is probably a good time just to put this in context with a couple of brief case studies. So this first one, Simon and Sarah in their 60s, each have children from their previous relationships and each own assets, although Sarah is wealthier than Simon. The parties enter into an agreement that says that property in their respective names will be retained in full by them, and any property in joint names is to be shared according to the legal title. The result is Simon and Sarah's children are happy knowing that their inheritances are protected, and Simon and Sarah are happy to know where they stand and being able to make informed financial decisions with known consequences if they do separate. Michael and Michelle have accumulated assets over their lives and would like to help their two adult children set themselves up financially. They tell their children that they'd like to give them $100,000 each, but they want them to enter into a financial agreement with their partners so that if they do separate, that money goes to the child and not their former partner. Children enter into the financial agreements with their spouses that say if they separate, they receive the first $100,000 and the balance is divided equally. And this deals with the scenario I mentioned earlier in the context of a business. Bob and Brian own a real estate company that's doing really well. They've two key staff that they'd like to bring on board and make equity owners. Those two staff members are in their late 30s with young children and relatively few assets. Bob and Brian having a financial agreement with their spouse is a condition of buy-in. The two new owners enter into a financial agreement with their spouses that's fair to them, but says how their interest in the business is to be valued, and that provides, and which provides that any payment to the spouse is staggered to protect cash flow. And so, just in summary, there are no, financial agreements can be a very useful asset protection tool. To answer the question that this presentation posed, they are worth the piece of paper they're written on if drafted properly. But there are no, and there can be no gilt-edged guarantees that they won't get set aside for a number of reasons. Nevertheless, even if in the end they are not binding, but generally speaking, it's better to have a non-binding financial agreement than nothing at all. At the very least, it can be used as evidence to show the intention of the parties, or to provide a record of assets owned at the time of the agreement, which often coincides with the beginning of a relationship. So that's the end of the formal part of my presentation. I'm happy to take any questions.
Thank you very much, Daniel. We've actually already received some excellent questions. So we've had some in the chat function, so I'll just throw some of those at you. Hopefully, I'm sure you'll be able to answer them, in fact. The first one is, what are the common mistakes that you see with parties interested in BFAs? Let's say they've tried to do their own thing, or you've seen a poorly drafted one. What are the common sort of mistakes you see, or I guess pitfalls to be avoided, the sort of that someone without your skill might accidentally do?
Yeah, well, the first thing is obviously that there is an obligation on the lawyers to make sure that the agreements are well drafted and meet the necessary technical requirements. It isn't possible for parties themselves to enter into a binding financial agreement without lawyers. That is a clear requirement of the legislation. So the answer in part should be addressed to the lawyers, at least as much as the parties. But in general, I'd say some of the things I touched on earlier remain paramount. Making sure, as well as making sure that the formal technical requirements are met in the legislation. I think a common trap is trying to have an agreement that is overly ambitious, trying to set out either so many different infinite scenarios that may or may not occur into the future that actually makes the agreement quite difficult to interpret, or not reflective of the financial circumstances of the parties at the time it needs to be enforced, or kind of the opposite, or the reverse side of the coin, which is to actually say very little and just assume that the what would be fair now in terms of a split will be fair in 20 years' time, and not to cater for those different changes of circumstances. So, for example, not to consider the need for a sunset clause if the parties have children, or whether all the property that the parties ever own need to be included in the agreement, and so on.
Okay, that's great. So really what you're saying is that they can be a great solution, but they're certainly not a set and forget, and perhaps they need a sort of periodic review.
That'd be a good way of putting it. A bit like a will. I hear that phrase used a lot as well. A will is not a set and forget as well. And I think whenever there are major life changes, I think this applies to both wills and financial agreements, or significant financial, it may be the birth of a child or loss of a job, whatever it may be, that may be the trigger to at least review and see whether the terms of the financial agreement remain appropriate. Okay, now this next question I've got might be my favourite question I've received, and it's clear that we're talking to accountants today. And basically is there a net worth threshold, perhaps, that you would consider at which point, actually, if you've got net assets of over X and you're entering into a marriage or relationship, that's the point where you should start thinking it's probably some value in getting a binding financial agreement? It's a good question. It's all relative, because what is significant wealth to one person would be not very much to another. But I think probably the way I can answer that best is to say that if we're dealing with a young couple just starting out, and there are there's no great disparity in their wealth, I would not recommend a financial agreement generally to that couple. Where it's much more likely to be relevant is a couple later in life, often a second marriage for both. They may have children from previous relationships, and there is more likely at that later stage of life to have a disparity in wealth. That may be 500,000, it might be 5 million, it could be whatever the case may be. So it's likely to be important for the wealthier party to want to, as a priority, ensure that perhaps having just gone through a potentially traumatic separation once in their life, that if they were to separate again, that at least they've got the agreement this time to protect them, which would almost certainly quarantine in some form the assets they brought to the relationship. But yeah, it's certainly not the case that there's a set dollar figure beyond which it's important to consider it, because it's more what's relevant for the party's overall stage of life and their overall circumstances.
Okay, look, that's a really good answer. That's a very considered answer. I suppose perhaps, and I'm aware that there are a lot of accountants listening, perhaps maybe then another related question might be that what would be the sort of cost of a sort of average BFA? And I appreciate I'm putting you on the spot a little bit there, and there are a lot of variables that can go into it. But if there was something that was close to an average one, then if our listeners are thinking about advising it to a client, then they can make that sort of risk rewards calculation themselves.
Yeah, somewhere between around $5,000 to $10,000. That's just a broad estimate. I mean, it really does depend on the nature of the agreement, how complex it is, and there's also to consider in terms of, from my perspective, the advice I'd give to a client in terms of a cost estimate that I'd give to a client in terms of drafting the agreement from the beginning would be different to being the lawyer who is required to give advice about an agreement that the other lawyer has drafted in the first place. Probably the other important factor is also whether the couple themselves have actually already reached the terms of the agreement. They're pretty clear what they want. It's relatively straightforward to implement. If that is the case, then I can start to put pen to paper, as it were, early on, whereas that often is not the case, and that the couple or my client may only have a very hazy idea of what they want, and so I can spend a period of time in helping the client to actually reach the agreement in theory in the first place. But $5,000 to $10,000 is a broad kind of rule of thumb or broad brush estimate, I would say, in many cases.
Daniel, sorry, Mark. Daniel, have you seen BFAs interact with bankruptcy, and have you seen, the insolvency or the bankruptcy of one party and how BFAs interact?
There is a lot of law around that, and I personally haven't dealt with many cases in that context, except one important thing that would be, I think, of interest to everybody is that there is a very specific law in place that states that a financial agreement cannot be used in any way to get around the insolvency provisions that are otherwise in place. I think there was a case about 15-20 years ago where again, this was pretty high profile, where a businessman was about to go broke and did a side deal effectively with his wife, entered into a financial agreement in which she got everything, and presumably there was some side agreement that in due course he would get some of that back. I don't recall the exact outcome of that case, but I think from memory the couple got away with it, which then led to a change of the law, which gave a creditor or a trustee in bankruptcy the right to ensure that method is no longer available. But yeah, that's sort of a fairly high level answer, I appreciate, but yeah.
And sorry, just one of the questions that has come up is about the interaction between a will and a BFA. and what takes precedent, especially if the will is different to what the BFA has allowed?
Yeah, I mean that's a good question as well. That's one I often get asked about as well, and clients sometimes get confused between a financial agreement and a mutual will, for example. So often in a first phone call or a meeting, I'll say, just to make the distinction, that there's one of two things will happen in this relationship. Either one of you will die first, or the relationship will end. So I only deal with the latter, and you need to see a wills lawyer to deal with the former. The family law legislation does actually say that a financial agreement that is binding on parties continues to operate despite the death of the parties to an agreement. I gather, however, the precise effect of that piece of legislation it's unclear, and that there have been various debates in this area, including whether or not the couple have to be separated before the death for that to apply. My understanding is that there's also a conflict between this part of the legislation and state-based legislation in relation to the making of wills, testators, family maintenance. So in terms of avoiding any testator maintenance claim or reducing that risk, it's certainly not safe to rely exclusively on a financial agreement in exchange for properly drawn will or mutual wills.
Excellent. So the relationship's going to end with you separating or someone's going to die, and yeah, he says family laws are not romantic.
That's right. There you go.
So is there any alternatives to a BFA? Like could you have a non-binding financial agreement, or is there any other process you could take that's maybe well, obviously you can do whatever you like, but are there any processes that are perhaps worth the efforts, or any alternatives to a BFA if you're looking at another asset protection tool?
Well, yes and no. I mean, there's certainly a big difference between the types of estate planning or asset protection that can be done in the commercial world as opposed to the family law world, where in the family law world, the family court have huge power to look beyond formal ownership of assets, and even to set aside any formal legal agreement if the intention is clearly to divert assets away from a potential property settlement claim. So placing assets into a family trust, leaving the spouse as a discretionary beneficiary, that may be a good tool for tax or against third-party creditors. Or it may not be, and again, that's not my expertise, but certainly in family law terms, if the spouse has any form of control over the trust, that's as good as formal ownership. Another scenario that often comes about is there may be a written loan agreement between parents, and they lend money to the son or daughter, often say a deposit for their first home. And sometimes that agreement is not done in a particularly formal way, or it's not signed. And if the parties separate, this is obviously in the absence of a financial agreement. If the parties separate, the courts are going to scrutinize that loan agreement and look at the underlying reality of how the loan was formed and whether in fact it's ever likely to be repaid. Often the intention is clear that it's not going to be repaid, in which case the family court would or can simply disregard it and have the monies treated as a gift. So a financial agreement would certainly be more effective in that scenario than a written loan agreement between parents and children. I'm not dismissing that as a maybe more pragmatic arrangement either, but the short answer really to your question is that in the family law context, there is only one true form of asset protection, and that is a financial agreement, which itself is subject to the various caveats and concerns I mentioned earlier in terms of potential circumstances in which they can be set aside and disregarded.
Okay, that's really interesting, and certainly, yeah, suggests if you're worried that BFA really is the way to go. Can you add any non-financial considerations into the BFA? For instance, I think it was mentioned in your slides earlier, like if Brad Pitt cheats, then it affects the money that he would get, or it affects the division of assets in a divorce. Is there anything, more sort of non-financial that can go in that can affect the outcome, or can just be a prerequisite of receiving something in the event of a divorce and a separation of assets?
It's a good question. My instinct is that no, that wouldn't be allowed. I don't think I can point to any standalone statute or case law that says so. I think probably need to be considered on a case-by-case basis. I think in practice those clauses would run into trouble on basic contract law principles, which is that you can't enter into any type of agreement that's contrary to public policy. And the public policy in the case of, let's say an agreement said that if a party was to have an affair, they are penalized and they don't get any of the assets, or their share is deducted. That would almost be trying to reintroduce a fault element by the back door, which is what the Family Law Act did away with when that was introduced back in 1975. So I think a clause such as that is, or maybe even the whole agreement would be void. And I can't imagine a court would want to get into that territory or upholding that sort of agreement. But it may be subjective. It may, to some extent, it may need to be considered on a case-by-case basis.
So tread with caution if you are.
Yeah, I mean, I just my natural conservatism with these types of agreements is that if there's anything that looks a bit odd or a bit out there, a bit outside the box, I'm likely to advise clients either not to have it included, or at least make sure they understand very much that by having that type of clause included, it potentially places the risk agreement of being set aside. Thankfully, I haven't. I don't think I've had that type of scenario that I've had to deal with. But yeah, financial agreements is probably not an area where it is important to think outside the box. It's not. You can be creative to a degree, but as soon as you start to be too creative, that's where problems lay, I think.
That's excellent. Now, I've had just one more question, and it relates to cryptocurrency. So we're being very, very up to date here.
Sure.
Which
I'll say in advance I know very little about, but I'll do my best to answer the question.
It's okay. Well, let's say that I entered into a binding financial agreement 10 years ago, and I said, just whatever happens, I'm keeping my 10 Bitcoin. And my wife signs it because they're worth $100 each, and now they're worth $70,000 each a few years later, and I want to get divorced. Then I should say this is all hypothetical. Then if there was a dramatic change in the underlying asset that was being quarantined, does that have any impact? Is that something that would maybe lead to a change in like an update to the agreement, or would it just be, we agreed when this asset wasn't worth anything, you get to keep it, now it's worth a lot of money, that's just the contract is the contract? I
think it's most likely to be the contract is the contract, assuming that the structure of the agreement is otherwise fair and if all the relevant formalities have been complied with. So the mere fact that the person with the cryptocurrency has had a windfall, that itself is not a ground to have it set aside. Again, I'd be interested to know what disclosure was given about that at the time. Was the other party aware, perhaps, that that they could be sitting on this this asset that could explode in value? Have they had children in the meantime, which means that there's hardship cause if the financial agreement isn't set aside? So yeah, it's an interesting scenario. I'd say really, the short answer is the mere massive increase of the asset itself is not itself a ground to set aside, though.
Daniel, just before we go on, I know we're coming very closely to 1 p.m. But I like I had to ask this question because it's just been posed by someone. What would you charge for the BFA for Bill and Melinda Gates? Standard $5,000 or $10,000? Is that the sort of charge for that?
I would love to. I hope that scenario occurs. It would be very interesting if someone got a phone call and it was either of them on the phone. But I think the more serious answer is if you're actually dealing with a case in the squillions, it is appropriate to charge more because the liability to us as the practitioners becomes that much more significant. As a matter of fairness to the client, what we're doing is we're I mean, the Bill Gates scenario is a bit different in that they're already separated. But if let's say they had come to me, a year or two ago, the impact of a agreement that actually is upheld would save them squilling. So it would be appropriate to charge more than the 5 to 10K that the ordinary person would feel is appropriate. So.
And of course, Daniel, you would engage Rogers Reedy to assist in the forensic side of it. Call Mark.
Absolutely.
Yeah, excellent. Daniel, absolutely. Mark, thank you for today's presentation. You can see by the amount of questions we've got, and we've got more coming through, that it's a very live issue. And as I said before, people come across it often. But the important thing is everyone's met Daniel today, so you've got Daniel's details on their website. Please reach out to Daniel if you haven't met him before, and if you have any issues and you've got clients in this space, reach out to Daniel to assist. So as I've said, we've got 240 attendees today, so hopefully you can all reach out to Daniel in that space. Thank you, Daniel. Thank you, Mark.
Thank you, Mark.
Thank you.
Excellent. That's it for today. Our next session is a general session, and that is on the state of the Australian rural economy. We've got a couple of we've got a member of Parliament who's going to present, and with a couple of other people in the rural area. That's the next session. That's on the 26th of May. The next accounting session specifically will be at the end of May, at the start of June, and that invite will come out in the next couple of weeks. Thank you, everyone. Once again, we appreciate everyone coming on board. Have a lovely day. Speak to you soon. Bye-bye.